Welcome to the Brigham Young University Family History Library webinar series. Feel free to use the chat box for any questions. If we are unable to get them during the presentation, they will be answered at the end. My name is Braden Knutson. I will be your host for this webinar. Today we will be pleased to hear from James Tanner, who will be giving a presentation titled, "You Do Not Own Your Ancestors." James Tanner has a bachelor's degree in Spanish and a master's degree in linguistics from the University of Utah. He received a Juris Doctor degree in law at Arizona State University. He served for 2 years as an intelligence analyst for the U.S. Army and 39 years as an Arizona trial attorney. He has previously owned a retail computer business and an Apple Macintosh software company. James has over 32 years experience in genealogical research and is an avid blogger of Genealogy Star blog and Rejoice and Be Exceedingly Glad. He served for 10 years as a missionary at the Mesa, Arizona Family Search Library and is currently serving at the BYU Family History Library. He has presented at expos and conferences around the U.S. and Canada. James has 7 children and 33 grandchildren.
Howdy. Welcome to the BYU Family History Library webinar series. We're going to talk about the fact that you do not own your own ancestors and explain what I mean by that. I might mention that this particular class was, or as a class, was given 2 years ago at Roots Tech in Salt Lake City. First of all, we have to address the challenge. What is it that we're talking about when I take the position that you don't own your ancestors? We have a constant loss of genealogical research. This occurs when people who have been genealogical researchers during their lifetime die or go into care centers or otherwise become incapacitated and unable to either maintain their records or communicate to someone which records are important, which are not. What we've seen over the years is many instances, some of which were tragic. In one case, I was speaking at a conference in Florida for a genealogical society, a rather large one, and one of the members of the society came in carrying some boxes, and he related the story that one of their members had recently passed away, and he had gone over to see how the sale of the apartment or house where he was living was going, and found the people, whoever they were, the heirs or children or whatever, on their way to the dumpster with the genealogy files, which he then intercepted and retrieved and brought to the meeting, and was hopefully going to be preserved. I think that's the closest call that I can recall, that I'm familiar with. What I might mention also that for many years I did research at the Family History Library in Salt Lake City, and one of the things that I was constantly aware of was the fact that my family had told me stories about my great-grandmother who had spent her entire life, 30 plus years of her life, doing genealogical research. As I went to the library in Salt Lake, I was constantly had that in my mind, and I would come back from the library and I would say, well, if Grandma Morgan did all that work, I don't know where it went, because I don't see very much at the library. And as a matter of fact, what happened is that I understood from other members of the family that there had been a pile of boxes that had been put in a garage someplace, and I was assuming that they'd been long lost. Well, one day, we lived in Mesa, Arizona, and one day my mother was traveling to Salt Lake, and she came back and she said that her sister, my aunt, had a pile of boxes that she was going to throw away, and she thought they might be genealogy, and did I want them? And I said, obviously, yes, of course I do. I forgot about that, and then a couple of months later, my mother returned from another trip to Salt Lake, and called me and said, well, I got the boxes you wanted. And so I went over to her house and I retrieved the boxes. And when I brought them home, I realized that this was probably most of what my great-grandmother's genealogy, and it had been preserved in the basement for, at that point, probably around 40 or 50 years. She died clear back in the 1950s. So that was a great lesson to me personally about the need to be concerned about where your genealogy records are going to end up so that there's not a loss. And it's only through um, the preservation of those particular documents that I was able to end up with them, which I then digitized the entire batch and donated the original records to the BYU Special Collections Library. So, and now, for example, all of those documents, the entire digitized copy of those documents is available on a CD through the Family History Library in Salt Lake. So that's the challenge. The challenge is that if you don't do something about taking care of your documents, there's a very, very good chance that they will get lost. Okay, the question comes up and says, and let me read the question. My father, an avid genealogical researcher, recently passed away. It's hard to know what to save and what to discard. When I add this to what I have inherited from my mother, I have a room full of boxes. What and how do I preserve what is important? Will the Family History Library digitize them for me? Well, I can answer the last one first. The Family History Library will not digitize anything for anybody because they're not in the business of doing that. The people, anyone who wants them digitized is going to have them digitized. What I would suggest is contacting some experienced genealogists in your area and have them come and review what's there, tell you what is important and what isn't important, and what needs to be digitized. There are people out there that I'm not at liberty to put onto a webinar like this, but there are people who actually make it their business to save collections of genealogical documents and then go through them and catalog them and make them available. So yes, the answer is I've done this over the years. I've done this a number of times. I've reviewed documents. In fact, since I've been here in Provo, Utah, living, I've spent some time with a family who had inherited from their mother a room full of boxes, a room full of documents, and we went through and I indicated to them that when they were ready, I would be glad to come in and show them which ones were and which ones were not of interest. Essentially, copies of things that might be online are not necessarily things we need to preserve. But if there are original documents and documents that cannot be replaced, then those need to be digitized. And the question is what to do with the digitized copies. We have a marvelous website called familysearch.org, Family Tree. It has a memories section in which all of those kinds of documents can be uploaded for free and maintained for family members. Okay, well that I think is a good question, and I think that we'll probably answer the rest of that in more depth in the rest of the presentation here. So here's the ultimate challenge: is our constant loss, sort of like a dripping faucet. I would think of it more as a larger leak than that because we lose whole collections at one time. It's kind of like leaving the faucet running. Well, what's the cause for this? Obviously, death is a fairly good reason why these documents end up in orphan status. Secondly, incapacity. That's another reason why the documents end up in this kind of orphan status. It's not uncommon when someone is advanced age and is no longer competent for a variety of reasons, that they're moved out of their home and into a care center or to come and live with one of the relatives or a child or someone. And at that point, their household furnishings and papers are usually either put in storage and then subsequently destroyed, or are destroyed at the time that they leave, because there's no one there to explain why they're important and why they should be kept. This usually occurs because of a basic problem, and that is that people believe that they own their research. Oh, okay. Braden just answered gave us another question. I see the basic reason why genealogical researchers lose their records when they die or go incapacitated is because of what I think the question has raised, and that is an issue of whether or not the children, the heirs, anyone who is the person that's going to end up with these documents, really understands what they are and what should and should not be preserved. The failure of the person who is doing the research to include the family and relatives usually stems from a very heightened sense of ownership and the overdeveloped sense of ownership. And it's very, very common among researchers to have the attitude that really nobody else should look at my data, and I don't want to show it to anybody until it's perfectly done. And of course, they die long before it's perfectly done. So that's why we never see that. Another factor in the loss of the data is that there's no provision made for preservation of the material on death or incapacity. In other words, the researcher has not talked to the people who would be the heirs, or if there are no close relatives who are heirs, a person is last of their line or something like that, has not talked to some other genealogically oriented organization or individuals about what they might do with the records and made disposition of those records before they pass on. In other words, they should be making all of these arrangements long before they get to the point of being incapacitated or before they die. And what's the result? The result is that years of research is often thrown away. As I mentioned, there's in a couple of those few examples, there seem to be a lot of other examples out there. This is a constant issue about with genealogists. Now, granted, some of the documents, some of the things that genealogists accrue in the course of doing their research are either incomprehensible because they're notes that nobody can quite understand or read, or they may be simply a work in progress that needs to be duplicated or redone. On the other hand, it's important to go through the records. Some of the people that we've inherited records from over the years that I've looked at, they had a tendency to put very valuable things in the middle of things that looked like they weren't of no value. So you'd be going through a folder of photocopies, and the next thing you know, you'd find an original signed document. So it's important that the documents be reviewed. Now, this probably occurs because as I mentioned, the genealogist refuses to share, and that comes about as due to a fear of loss of the ownership or the control of the documents. And this is it's a very common human reaction to think that if we spent 30 years or 40 years or whatever years, even if it's just 1 year, doing all this research, that it's my research and I want credit for it and I own it. So you need to ask yourself, and that is everyone ask themselves whether or not they think you own your genealogy. And I guess the secondary question is the one that's the theme of this webinar, and that is, do you own your ancestors? I think we'll answer those two questions. First, I think it'd be interesting to talk a minute about what is ownership. What do we mean when we say we own something? And I think that this is an area that people generally do not understand. So part of the other question that needs to be asked is, if we know what ownership is, how do we obtain the ownership? So let's look at ownership. Basically, ownership is a culturally determined status. Whether or not I own something, in a sense of I have absolute right to control, to dispose of it, to do with it what I wish to do, is determined by which kind of culture you have. There are many cultures that don't recognize personal property ownership, and some other cultures that do not recognize real property ownership. The concept is entirely foreign to their culture. But we come generally in the United States and in other parts of the world, we are in this day and age, most of us live in complex societies that recognize all sorts of different levels of ownership. And in addition to that, we have to have what's called legally recognized ownership. The most common way of understanding this is titled property. That is, property that you own only because someone on a piece of paper someplace recognizes you as the owner. For example, if you buy a lot or a piece of property, real property, I mean land, in many countries of the world, then you get a deed to that property. That deed is the evidence of your ownership. Other than that, you can establish your ownership by, in some places don't allow it, fencing the property, or defending it against intrusion, or posting signs, or doing all sorts of things that people do to exercise ownership over a piece of property. And of course, when they die, that property passes to some other individual. So we go from one person to another through what's called inheritance, or through other processes that happen because of other circumstances. In real property, for example, you can lose the property if you fail to pay the taxes on it. The government has a prior right of ownership to your personal ownership of the property, and when you don't pay your taxes, they can come in and take the property away from you. Okay, well, so ownership can get quite complicated in its different forms. So for example, if I own land, I have certain rights that go along with that ownership. I can post it to keep people out, but I mentioned that land ownership is only, even here in the United States and other places, is only a very recent development. When we say recent in genealogy, genealogy goes back thousands of years, and so we really don't mean recent in the sense of this year. We mean recent in the sense of the last few hundred years, maybe 1,000 years. In Europe, for example, and at the time when the colonists came to America, the monarch, the king, owned, or other queen, whoever, owned all the land. The only reason that settlers in the Americas were given land by either England or Spain or even Russia or other countries was that the king claimed sovereignty and gave the land to someone who sold it to someone who ended up being the person who came over on a boat. So ownership of land is something that illustrates the point that ownership is really a cultural artifact and legal artifact. Now, this is still the case, by the way, in the United States. As I mentioned, if you fail to pay your taxes, then you're going to have tax liens put against your property, and eventually your home will be sold or your piece of land will be sold to pay for the taxes. So you may think that you own your land absolutely. In fact, if you were buying a piece of property and you were the sole owner, um, you might receive what was called a fee simple or a fee absolute, where you owned all of the property. However, you're still subject to any kind of claims by the government to your land. We have a thing called eminent domain also. In that case, the government, in some circumstances, can take your property away from you even if they don't have a lien against it. And if you die, inheritance taxes may end up having your property sold to pay for the inheritance taxes. So here is the important fact: you will die. And you will be subject to whatever laws of inheritance that exist at the time that you die. This doesn't matter where you live in this world today. There are probably, I don't know if there are any islands in the ocean or places in the world where they don't have inheritance laws, but I would doubt that. I can't even imagine that that would not be the case. I think every piece of the world today is governed by some country's laws, and everybody has laws governing who inherits and how do you inherit property, if you do, in that particular country. So here's the ultimate question here. So who will be the executor or personal representative of your estate? Okay, many of us have wills, some of us don't. Many of us have trusts, and some of us don't have trusts. But you've named an executor or personal representative of your estate or a trustee for your trust. And the question is, what is that person's attitude towards your genealogical research? Do they know about it? Do they know what to do with it? Do they have any instructions on what to do? Okay, and the answer ultimately is, well, they care about your genealogy. Now, I can tell you right now, having done many, many, many years of probate law in the probate courts as an attorney, that the court will not place any value at all on the personal papers of someone. The only thing that you can get that will have any leverage in an estate as far as value are things that can be appraised and an appraiser can put a value on. And as far as I know, I have never seen anyone's papers, unless you were very, very famous and you wrote, all sorts of very famous things, and people were willing to buy your papers. Things like genealogy have never come up as being anything of value in an estate. Now, the value there is intrinsic, meaning a lot of work and time has gone into them. But that intrinsic value, the value that's been created through work, is not something that can be measured in money, and is not a value that will be even inventoried in an estate. In Arizona, for example, where I practice law, those kinds of things in an inventory of the estate came out as personal effects, value 0. So that's the way they were handled. And in addition to that, not just talking about the physical papers, but will the people who inherit your estate care about your years of genealogical research? In some cases, the genealogists have been so annoying to the family that they are actually antagonistic, and they reject the genealogical research and everything else that goes with it because they don't appreciate and or have no involvement in it. So what we're talking about here is the relationship between the genealogical researcher and those people who would preserve the documents and preserve the work and maybe even carry it forward if that person were to pass away. So let's ask yourself, what do you own? What is it that you own? You own personal property. That's anything that's movable. We call it personalty. It's and everything from cars to dinnerware to your clothes to books and anything else you happen to own. They're all considered to be personal property. That's opposed to real property, which is considered to be land. That's the actual physical ownership of land. And then you have a third type of property, and that's called intellectual property. And this is something that's been created in the last couple of hundred years as we recognize that people have some kind of property rights to the types of things that they create. It's usually preserved by what we call copyright laws. There are also patents and trademarks and all other kinds of intellectual property, but the area that we're most focused on in genealogy is what we call copyright. So the question to ask is, does genealogical research and do accumulated records fall into any of these categories? In other words, is what you do as a genealogist and the work that you produce and the records that you discover and the information that you record, does that fall into any of the categories that might be considered owned or ownership items in most European and other countries based on European law? So the question here is it intellectual property or personal property? And I guess the subsidiary question to that is there a copyright claim? Uh, and we're going to focus here on the United States because this is where I happen to be my expertise. But I would mention that you need to investigate around the world, you need to investigate which country governed the copyright. If the work was produced in England, say for example, then it may be subject to English copyright laws. In fact, it probably is if they apply at all. And you can extend that to every other country of the world. So uh, determining whether something is or is not covered by copyright can be quite complicated if those items are all created outside of one country. So there may be multiple copyright issues. But the question is, the basic question here is what genealogists do and what they produce something that is subject to copyright? And secondly, is there another concept out there that we might call work product? And I've heard people argue this. They say, well, I spent 30 years accumulating this information and I'm owed something for my time. And so therefore what I have produced is mine. I own it and it has value. Okay, well, that's an interesting argument, but it may or may not, it may not go anywhere. It's not necessarily a very convincing argument to someone who has practiced intellectual property law for many years. But that's it's an interesting question. And they use the term work product, by the way, which I'll show in a minute. We're going to go into these in a little more detail. I don't think it applies at all. Now, the last one is called sweat of the brow. And that's really what they're talking about when they say they spent all this time working on it and developing it. But that really is part of a copyright. It's where copyright comes in. The real essence of copyright is we're going to protect the, if you want to call it work product, you can, or sweat of the brow of the person who created this work. They will have an ownership interest in that work that we establish by statutory copyright. Okay, so how will the inheritance law treat genealogical research? Which category will they put it in? And how will they determine whether it has value and ownership? So let's kind of just briefly look at what is a copyright. Copyright is a created by law. First of all, it doesn't exist absent a law, a statute, something passed by a government protecting the rights of its citizens. There's no natural copyright law out there, meaning that arises from nature as a right. It is something that is a complete fabrication of law. And what is and what is not copyright protected is determined by those laws. So we don't, you can't say, well, I own this because I made it. The answer is, well, you own it only if you made it and only if it falls within the provisions of the copyright law in effect in the country where you created it. Okay, that's pretty complicated, but that's the way you would analyze the question. And then further, as far as copyright law is concerned, and in the English law, common law countries like the United States, which is primarily English common law, the law as it is is additionally interpreted by the courts. And so even though the statutes may not seem to cover the issue, if there are court decisions which cover the issue, you may still have some rights that are extended by the courts. One of the biggest areas of copyright law, by the way, and this is something we're not going to go into in depth, is a thing called fair use, a concept. We call it a doctrine of fair use. Fair use, by the way, is not created by law. It's a creation of the courts. And so in order to understand fair use, you go out and read a whole bunch of court cases and come to a conclusion about what you think is fair use. And that's kind of that is a very direct example of court interpreted or court created law. Okay, so the question is your genealogical research covered by copyright? Now, if it's not, then you have no official statutorily created ownership rights in the documents. And my answer to that is maybe. Some parts. Some of what you do and what you create as a genealogical researcher may in fact be covered by copyright. That's entirely possible. Now, should you assume your research is subject to copyright? And let's say you do. My answer to that is, so what? The answer I have is having something copyright protected does not create any more value in the eyes of your heirs if they don't understand what it is you have. So you may have copyright protected work. It still might have no value to anyone, including your heirs. And so the answer is, so what? Copyright does not confer value. Copyright confers legal rights to ownership. You own it, but I own a lot of things that are worthless. I couldn't sell them at a garage sale. In fact, when we moved from Mesa to Provo, Utah, from Mesa, Arizona to Provo, Utah, we very much used the dumpsters to get rid of a lot of stuff. Well, because we had stuff that didn't have any value. And if your heirs view your research, copyright protected or not, as not having no value, then that's the problem, not the issue of whether it's covered by copyright. Now, in order to have a copyright, in many cases in the past, and in some places in the world, you need to register your copyright with a copyright office, some government agency out there. Now, in the United States currently, everything that can be copyrighted is technically copyrighted from the moment it is put into some tangible form or medium. That has been the case since around the late 1880s, just right before 1890. I mean, excuse me, 1980s and 1990s. So if we all have automatic copyright on everything, then isn't that mean everything's copyrighted? Well, it's not quite that simple, but that's technically something you could do. If you want to enforce your copyright, if you wanted to, if someone copied your stuff and you for some reason felt that that was a violation of your copyright, you would then be required by the law in the United States to register your copyright with the Copyright Office before you could proceed with any kind of an legal enforcement action, go to court. And before you could file an action in the federal court, that registration requirement is what they call jurisdictional. It means you have to have registered in order to bring the action. So you're going to have to put out some money and hire an attorney and get involved in a court case if you want to enforce your action. Saying you have something copyrighted is very simple. You just create it and it's automatically copyrighted. But if you want to defend that against somebody making an unauthorized copy, then you have to go to the expense and time of putting that kind of information in a tangible form, register it with the Copyright Office, and then you'd have to come up with the money to file the action in a federal court. In the United States, all copyright cases have original jurisdiction in the federal court system. You cannot file a copyright action in a state court. Are published family history books automatically copyrighted? Yes, everything is automatically copyrighted. You don't have to do anything in the United States to enforce a copyright. There's no longer even a legal requirement to put a copyright notice on it. They're just automatically copyrighted. But what I'm talking about here is the practical ramifications of claiming that copyright. So even if you have written a published family history book and it's automatically copyrighted, is somebody going to spend the money to register it and file an action in the court if you make a copy of it? Of course, you do run the risk. And in the United States, under the U.S. law, which is what governs copyright, not state law particularly, although there are state copyright laws, the United States of America has a provision for what we call statutory damages and attorney's fees, which means that even if I can't prove in any external way that copying my family history book damaged me, I am still entitled, if there's a violation of the copyright, I may be, if the court awarded it, I may be entitled to the statutory damages, and that's set by whatever the statute is that applies to that particular action. And I may be able to recover some or all of my attorney's fees, and the operative word here is may. It does not mean you're absolutely entitled to it. You would still have to go to court and be awarded those charges and come up with the money in the first place. So the answer, yes, anything published is automatically copyrighted. I'm gonna kind of diverge here to a different way that the law is applied. In the United Kingdom, they have copyright protection under their law that extends to databases. Now, a database is an accumulation of information, and clearly, from almost any standpoint, a collection of family history information could be and would be considered a database. And the question still is, does the law apply to genealogical research? So they have this law in the UK that says that that people can obtain a copyright if they create a database with certain information. The idea there is to protect the work product, the the work that goes into it, the sweat of the brow work that went into creating the database. Well, here's the key though. Whether or not the law of copyright applies, that does not have anything at all to do with the fact that your work will or will not be preserved. So you're not going to have your work preserved simply because it's copyrighted. That just isn't the way it works. Um, it's only preserved if people value what you've done and take the effort and time to preserve it. And you can do that by giving it to an institution if they'll take it, and or putting it someplace in your own from your own arrangements that it is preserved. So this is something we need to be concerned about. It's not, we too many people get into the situation where they think that, oh, well, I've created this wonderful book, and then I have it's going to be preserved forever. And the answer is not if nobody wants it. They're just throw it away like they do anything else. So you have to take the time and make the effort to have someone value it. Now, then the question comes up is, um, are copyrights inherited? And the answer to that is yes, they are. They are personal property right, recognized. It's an ownership right, and yes, it can be inherited. In fact, that's one of the reasons for the existence of the copyright is that the work can be inherited. Now, the question is, do I have the right to reproduce my father's books? Well, the only answer to that I could give, and unfortunately it's going to come from my background as an attorney, is yes, if you happen to be the person who inherited it. Now, if they didn't leave you the book, then you may have to negotiate with all the other heirs or get an assignment from them in order to have the right to reproduce it. Um, Unfortunately, because there is little value placed on genealogical research, even books, um, it is generally not specified in the will. So if you get into a long question on probate, for example, probate gets quite complicated, and we'll probably have webinars that talk about it. But essentially, the court determines after looking at the will and any other facts or evidence that are brought before the court as to who the heirs are and what is the property that should pass. This could be as simple as having one heir who receives all the property and all the interest, or it could be distributed among many heirs. And so if you put some value on this book, you're simply, unless it was specifically given to you in a probate action, your question is still, from a legal standpoint, is still unanswered because the question of the joint ownership of all of the heirs was never determined. Now that's a complicated way to answer the question, and I really, unfortunately, some of these questions do not have simple answers, and that's one of them. That's a good question, really good question, because it brings up a lot of the other issues that we're talking about here. Now, there's a basic law, and it's pretty well established here in the United States, and that's the reason why I mentioned the UK laws that extend to databases. Normally, you would not have any legal interest in or copyright interest in facts. If I say the world is round, and that is a fact, well, even some people don't believe that, but let's assume that it is a fact. Even though I've said that, put that in writing and or published it, I can't technically copyright that because it's something that's a factual nature. Now, if I say that I am related to such and such person who is my great-great-grandfather or great-great-great-grandfather or whatever, that's a fact. And the central argument here has been that the facts of what you're accumulating is in genealogy primarily is facts, and therefore they cannot be copyrighted. If it were that simple, I wouldn't have had to do a webinar on this subject. So, but that's part of the argument. Okay, so first of all, if we look at genealogy, and if I looked at what I would call my genealogical file, it would be comprised of a certain number of things. First of all, it would be comprised of a lot of facts that I pulled out of a lot of different places that we would call sources, records and documents that I used to compile my genealogy. And all of those source documents do not ever pass to you. In other words, you do not own a copyright to the United States Census. So if you include a copy of a census document, that census document is still not under copyright to you. You can't copyright it. So if I copied your census document that you put in your book or you're in your records, that would not create a copyright right of action. So there's significant portions of your research that are not available under the copyright law at all. And I can mention this, and I've checked this periodically. No court has yet held genealogical research to be subject to copyright claims. So if you were to take that, you'd be the first one. So in other words, are you the one that wants to be the first one determining this? Okay, so then another question's come up about a bound copy of an ancestor's original journal. Is this a source document? Well, are we talking about a copy of the original journal or the original journal? The answer to that is it may be a copy. If it's a copy of it, then whoever made the copy could own the copyright. The person who wrote the journal may have had a copyright, and it may have been inherited by the person who bound the copy of the journal. So the answer to that is it depends. Is it a source document? Well, yeah, but that has nothing at all to do with copyright, anything like that. An original journal definitely would be a source document, but it would not be. It may be copyrighted. Now, if you reproduce the entire journal, you could possibly end up violating someone's copyright. So that's, or even if you took out a significant amount of the journal, that amount is what we call fair use, and that's what I said has been determined by court cases in the United States. And it basically every single instance of the raising of fair use doctrine has to be determined on its own facts. There's nothing you can generalize about that. Okay, so let's go back to the issue of work product. In the law, work product has a very narrow meaning, legal meaning. Work product is limited to work done for hire that is not subject to legal discovery. That's it. That's the whole. That's what work product means. It's a lovely term that's been thrown around by people, but when you get right down to the legal basis for this idea, it only applies to work for hire that's not subject to legal discovery, and the primary work product exclusion from legal discovery applies to attorney notes or research. So the research that I did as an attorney and my notes are under most circumstances not discoverable. But let me mention that if we go into certain cases and into certain types of actions in the court, my notes as an attorney, even though they were my work product, could have been discoverable, meaning that they could be brought out in court and used as evidence. So we have to look at the facts of each case. Additionally, that my work product, in other words, what I produce for any one client, is not my work at all. It is the client's work. And that's why it's work done for hire. In other words, I'm hired as an attorney, I produce the work, and it's subject to work product, which means it's not discoverable by the court in a court action by the other side. They'd say, oh, they'd love to like to read what I had to say about the case, but it's not discoverable. And that means that it can't come out in a trial as evidence. But it's the client's work product. Even though I produced it, he owns it. He or she, he or the client owns it. And work product is not sweat of the brow. So when you use the term work product in the concept of I produced all this information and it's my work product and therefore I should be compensated and I own it, and the answer is none of that follows. There is no legal, you haven't said anything in the context of the law, at least in the United States, that that creates any ownership rights at all. So we need to understand if it isn't copyright protected, then it's probably not sweat of the brow protected, at least here. Now, what about property owned in common? Okay, we have lots of property out there. Parks. Oh, we got another question. Question is, if I hire a photographer, do I own the photos or the photographer own the photos? Well, that's an interesting question. Most photographers have you sign, a professional photographer will have you sign a release form that says that they own the photos. They're called model releases. And if you go into a professional commercial photographer to have a photo done, they'll have you sign a contract. And part of that contract will say that the photographer owns the rights to reproduce the document. And they can sell or assign those rights to you. So the answer is probably not, because this is an area of contract. And so it's not the same as an attorney representing a client. The photographer will then negotiate. Now, what if the photographer never says that? In other words, it never comes up that the photographer is taking any ownership. You don't sign a contract. It's an informal agreement. If you've never talked about it, then you have a pretty good argument that you do own the photographs that they've taken, because it's called work for hire, and work for hire is generally copyright protected to the person hiring the work, the owner. It becomes the owner. But I would mention it, repeat that, because it's important that in most of these circumstances, and particularly with professional photographers, you will end up negotiating those rights, and you will only have a limited right to reproducing the photographs. Okay, back to common property. Common area, for example, if you live in a subdivision that has a homeowners association or something similar to that, some kind of owners association, you may own certain parts of the area in common with other owners. In the United States, for example, as citizens of the United States, we jointly own our government lands as citizens. So those are all common areas. Roads, for example, are another common area. You don't own your road unless maybe you do. I mean, you can actually have a road on your own property that you own, and you've never given it over to the government. But if you're driving on the government's roads, then you own those roads only in the sense that you and everyone else who drives on the road owns the road. But you shouldn't drive like you own the road. That's not a good idea. So even if you do. Okay. Remember this as the basic issue, and that is information about your ancestors is available in common. You did research, that's great. I could go reproduce that same research, unless you burned it all after you researched it. I mean, I assume that's possible, but not likely. Oh, the additional question is, is that apply to genealogists? Absolutely. If you substituted the word genealogist for photographer and everything that I said, then you will probably come up against exactly the same problems and issues. If you hire a genealogist, you're going to have some sort of agreement, usually in writing, and if the genealogist is a professional genealogist and has been doing it for any length of time, they will they will specify. If they don't, they're not very professional, if you want my opinion, but they will specify who owns the work and what they would be able to do with it. Most genealogists, by the way, if they do the research, will reserve the right to use that research in any other their subsequent publications. So, in a sense, you transfer the ownership of that to the genealogist. Okay, well, we're back to information about your ancestors being available in common, and that means that if I find out who my great-great-grandfather is, he's likely someone else's great-great-grandfather, and they have just as equal right to the information about their grandfather as I have to my grandfather. So hence we get to the title of this, that you don't own your ancestors. I can't own my great-great-grandfather. I always say this: slavery in the United States ended with in the Civil War with the Emancipation Proclamation and the subsequent constitutional law changes and the enforcement of those changes. So you really can't own your ancestors any more than you could own slaves presently in the United States. And information, once again, facts, information is not subject to copyright in the US. The case that we have in this is called Feist Publications versus Rural Telephone Service. And that particular case is very interesting because even though we don't have a case talking specifically about genealogical research, we do have this case talking about telephone directories, accumulations of the same or similar kind of information, directories, lists of ancestors, about the same thing. Okay, so, well, you're not going to say, no, my genealogy is certainly not a telephone directory. And the answer is, well, no, it isn't. But from a legal standpoint, if you ask me, I'd say, yeah, they're about the same thing. So in the United States, to qualify for copyright protection, a work must be original to the author, and that means it has to be independently created, and it has to possess at least some minimal degree of creativity. And it can be original even though it closely resembles other work, so long as it's not a result of copying. In other words, just because it looks the same, it doesn't mean it was a copy. So in this particular case, the rural telephone service supplied service to various communities, and it had to issue an annual telephone book. So it published a directory consisting of white and yellow pages. And the yellow pages have advertisement that generate revenue. The defendant here, Feist, it was Feist who was sued, and this went to the United States Supreme Court, so their name came out first. They reverse positions as they go on appeal, by the way, and that gets pretty confusing. But they were the people who were being sued. They were a publishing company, and they simply copied the listings in the directory. So they used them without consent, and so Rural Telephone Service sued Feist for copyright infringement. And what happened? The court ruled against, and they said that a list of names can't be copyrighted. Okay, well that may not be the exact closest case that we have to genealogy, but it is certainly a good indication of what the court might do if we ever force the issue. Okay, so now there's kind of a minor issue here, and this is brought up all the time. It's plagiarism. Well, plagiarism is kind of a slippery concept. It really has to do with academic world, and it's not a question of ownership at all. Whether I plagiarize somebody, meaning I fail to attribute their work or what they did or their contribution, that's not necessarily a question of ownership at all. It doesn't really transfer ownership. So plagiarism, this is one definition. It's the practice of taking someone else's work and passing them off as one's own. No intent here to own or copyright or whatever, but it may be immoral, but it isn't illegal. And sometimes people confuse plagiarism with copyright claims. So rather than they say that I was plagiarized, meaning, well, they copied my copyrighted work. On the other hand, sometimes they say that that I violated copyright when in fact all I did was fail to give them proper credit for some idea. So it's a moral and usually an academic issue. By and large, plagiarism law cases involve students suing an academic institution. So if you sue, I mean, if a student sues an academic institution for taking their paper, whatever, using it and not giving them attribution, that happens the most frequently. And guess what? They almost always lose. The problem with this is that the original author is not usually involved in the student lawsuits. So the students sue because they produced a paper and nobody copied that paper and didn't give them attribution, didn't say that they were the original author, but they weren't the original author because they produced it from other documents that were not necessarily created by them. And it's also very hard to prove plagiarism. And it's usually mixed in with copyright issues. And plagiarism involves a concept called derivative works. And we don't have time in this particular presentation to go into the whole concept of derivative works, but they're works that are derived from some other work. And basically, I mean, genealogists use derivative works, make derivative works all the time. We're always quoting journals, quoting census records, quoting all sorts of records, and we usually reproduce them exact word for word. It could be that plagiarism is a basis for a fraud claim, but that would the question there was who would bring the action, who was defrauded by the plagiarism, and the answer is, can you plagiarize the genealogy? And the question is one, family trees versus the commentary or the writing. Yes, you could plagiarize the commentary or the writing. A family tree is nothing more than a compilation of facts, and there is nothing there that can be plagiarized. So the conclusion here is that you do not own your ancestors. As much as you would like to claim ownership to that huge pile of paper you've accumulated as a genealogist, the other part of that is that since there's no ownership right there, you really do need to be involved in the issue of who's going to take care of it once you die. And if you really want to save your research, then share it and share it and share it. Put it online, make it available to all of your family members. The idea that you have done all this work and received some credit for it is is just not getting there. That's just not going to happen. It's not going to preserve it. The other option, of course, is to make specific provisions in your will or other testamentary documents for the preservation of your work. If you do that, you may or may not be successful in getting the work preserved. There's a great feeling out there that once you put it in a will, that the executor is absolutely bound by the provisions of the will. Let me tell you something. I could say I leave all my genealogical documents and I want them given to XYZ, to these different individuals or organizations, and the executor of my will could simply throw them in the garbage. If somebody raised the issue, they'd say they were of no value. And that's, and you're going to go to who's going to go to court and try to prove that you're now disposed of genealogical documents had value. Good luck. And then make sure you keep a complete copy of your documents and they're given to a responsible person before you die. So this is a great argument for digitizing all your documents and giving them to your heirs who appreciate what they're receiving. And do this before you become incapacitated or before you die. Well, thank you. That's
Okay, thank you very much, James, for the wonderful webinar. We will have this one posted on the BYU Family History Library website at the link on the bottom of the screen. There are also many other webinars, past webinars, at that link that you can go watch for other information and other research tools regarding family history work. Thank you.